Welcome to another episode of Husch Blackwell's False Claims Act Insights podcast. I'm your host, Jonathan Porter, and we've got a breaking news episode today. The False Claims Act is around 160 years old, so you may not expect a law that old to have breaking constitutionality news, but we do. On September 30th, a federal judge in Florida threw out a Qui Tam in which the government had declined to intervene. She said that the whistleblower could not proceed with the declined Qui Tam on the grounds that the Qui Tam provision of the False Claims Act violates Article 2 of the U.S. Constitution. This is a big deal in the False Claims Act world. It could have major ramifications for federal enforcement because, as we talked about in our very first episode of this podcast, whistleblowers largely drive DOJ's agenda when it comes to False Claims Act enforcement. In fact, 2 years ago, 89% of False Claims Act settlement dollars stemmed from investigations started by whistleblowers. And so if Qui Tams are unconstitutional, get ready for significant upheaval in the False Claims Act enforcement space. But are we really about to see that upheaval? Is this just an outlier, one-off case that won't gain traction at the Court of Appeals level? And while we figure out the appeals of this Florida federal court ruling, what should those under federal investigation do? How does this ruling change things right now? So we're convening this podcast to answer those questions. And lucky for you listeners, you don't have to rely on me for those answers. You get answers from two of the best, two of my favorites in the False Claims Act world, Jody Rudman and Lorinda Holloway. So longtime listeners will recognize them both from past episodes. Jody from our very first episode where we talked about whistleblowers, and Lorinda from our episode about FCA settlement mechanics and strategies. And so Jody and Lorinda, both from our Austin, Texas office, they're both veteran government investigations lawyers and FCA litigators and know this issue really, really well. And so I'm excited that you get to hear about this new case from them. And so Jody and Lorinda, thanks for coming on the podcast and telling our listeners about this new court ruling that declared Qui Tams unconstitutional.
Jonathan, thank you so much for having us. It's a pleasure to be back. I'm Jody, and I'll chime in here in just a few minutes, but I want to give the floor first to Lorinda to take on kind of what happened in Florida as we're all trying to parse through this exciting and really interesting issue.
Thank you. Yeah, this is Lorinda and Jonathan. Jody, delighted to be joining both of you on today's podcast. So Jonathan, like you said, this is kind of a breaking news moment in the False Claims Act world because Judge Mizell out of the Middle District of Florida declared that the Qui Tam provision of the False Claims Act is unconstitutional under the Appointments Clause. Now, as you said, this is a ruling. It's the first of its kind, but it's definitely not the first time that this issue has come up and has been battled, so to speak. Now, we're going to get into, I think, some really fascinating backstories of the justices and judges that have been talking about this constitutionality issue for some time. But let's just real quick let the audience know what this case was really about. It was filed by Dr. Clarissa Zafirov, and she was employed by a healthcare provider that she says was submitting false diagnosis data in order to trump up the payments they were owed by treating Medicare Advantage or Part C beneficiaries. The government investigated, as they're required to do under the False Claims Act, but they declined to intervene in the case, and that's not unusual. As you said, most False Claims Act cases are relator-driven, right? So that wasn't unusual. The relator went forward on her own. The case had been going for about 5 years, and the relator had even moved to Canada. At that point, not sure what the precise trigger was, but the defendant filed a motion for judgment on the pleadings, saying the Qui Tam provision, that the provisions that allow a private citizen to file a claim under the False Claims Act is unconstitutional. And the defense actually threw out kind of several options to the judge. They said, we think it's unconstitutional under the Take Care Clause of Article 2, under the Vesting Clause, and under the Appointments Clause. So kind of giving Judge Mizell a number of options, if you will. And Judge Mizell picked up and leaned hard into the idea that the Qui Tam provision is unconstitutional under the Appointments Clause. So when Judge Mizell, in making her decision, she found that the Qui Tam provision is unconstitutional under the Appointments Clause. And just to remind everybody, even those of us who went to law school probably haven't reread the Constitution recently, or maybe you have, but the appointments clause in Article 2 is what gives the executive branch the power and duty to appoint agency heads, senior government official, federal judges, and the like. And then there's sort of a cascade of lower level officers, if you will, that can also be appointed through those other higher up government officials, right? So Judge Mizell concluded that a relator acts as, quote, an officer, much like a special prosecutor. But her conclusion was essentially a relator is a self-appointed officer of the government and not one properly appointed. So in other words, she thought the case can't go forward because you've got somebody acting in a role that they were not appointed for.
Yeah, thanks, Lorinda, for that background. That's really helpful. You're absolutely right. So the rough math when I was at DOJ was that DOJ only intervened in about 1 in 5 Qui Tam. So you're absolutely right. Nothing unusual about the government declining. So that's totally normal. I'm curious, though, even when I was at DOJ, the Qui Tams where we had declined, I took seriously my job to monitor the Qui Tams and to jump in and speak up on behalf of the United States when there was something interesting going on that I thought was wrong. So I'm curious, and Jody, I'll throw this to you first. What did the government have to say about this issue, if anything?
Yeah, that's a great question. And indeed, you're right. Even in non-intervened cases, the Department of Justice generally does monitor the litigation and has the right to step in on important issues, even to intervene at a late date, and even to move to dismiss down the road in a non-intervened case. And that was a decision that the Supreme Court took up just a couple terms ago in the Polanski case, which we will talk about. But in this particular case, when the constitutional issues were teed up on the defendant's motion for judgment on the pleadings, the United States filed a 20-page statement of interest arguing these constitutional issues. And they had a very well-written and scholarly and historically driven 20-page piece. And they are entitled to do that, not only in their monitoring obligations within the structure of the False Claims Act and the Qui Tam device, but also under statute in general. And so they jumped in and took a very strong position that, hey, look, this issue, this constitutionality of the Qui Tam provisions of the False Claims Act issue is already been decided, already been looked at, already been adjudicated in a number of other circuit courts. Those are the appellate courts that sit over the trial courts in the federal system, and indeed by sister trial courts to Judge Mizell's Middle District of Florida bench. And my understanding, Jonathan, is that in addition to filing that statement of interest and getting involved in the briefing, there was a 4-hour hearing before Judge Mizell made the decision and issued her opinion in the Zafirov case, and that the United States, the Department of Justice, was involved in that 4-hour hearing as well. So they were quite actively, as you would have done, I'm sure, in your days at the Department of Justice, and as you would expect, involved in litigating these issues. And the position that they took, and I'll leave some of this discussion to Lorinda as well, but the position that they took was what you would have expected with an examination of what other courts had already said about these issues. Because this court in the Middle District of Florida, any appeal that comes from it will go to the 11th Circuit Court of Appeals, but other circuit courts, namely the 5th, the 6th, the 10th, the 9th, had themselves already considered in some form or fashion the Article 2 challenge to the Qui Tam provisions of the False Claims Act. The 11th had not. And so the United States' position was largely driven, as one might be expected, by the opinions that had been issued in those other circuit courts. But let Lorinda talk about that in a little more depth as well.
Yeah, I think the government, in filing their statement of interest, as Jody said, made it clear, like, hey, whoa, time out. A bunch of these circuit courts have already looked at this issue, the 5th, the 6th, 9th, 10th, kind of like, hey, this is not a real deal, right? But they also argued some additional points that I thought were strong and certainly seemed solid. Like, hey, The relator is literally not the government, nor its agent. And they cited Supreme Court authority for that. They said, plus the executive branch, meaning the president, actually has considerable control over the relator. So we're not infringing on any constitutional limits here. The government also pointed to the fact that the relator is literally not, quote, an officer appointed by the president. So the appointments clause is just not an issue, almost like a pretty simple, straightforward argument, which a number of other courts have relied on. And so the federal government made their position very clear. They made it pretty concisely. It was thorough, but nothing, I guess, creative or different than had been argued before.
Yeah. So to me, Qui Tams are so unique because there are so many more parties that are interested in Qui Tams than in normal litigation. Relators and the government are on the same side of the V. They don't always have the same agenda or interests. And so it is really interesting. Sometimes you see DOJ get on, actually be opposite to the relator, where they join the defense and say, look, we don't think this is something that should go forward. Affirmative dismissals are a big thing right now in the False Claims Act world. But it's interesting here that DOJ chimed in and said, no, we like Qui Tams. We want these Qui Tams to continue to be a thing. But what's interesting to me, and Jody, I'll throw this to you, Qui Tams, they've been around for a long time, right? Why exactly is this happening now? This seems like something that could have been adjudicated a while ago. So what's going on? Why is this happening now?
What a great question. There is some really interesting historical seedlings in, I think, what leads to this current opinion. And you're right. The False Claims Act has been around since the Civil War. In the mid-'80s, there were some amendments that really started to amp up relator involvement in False Claims Act litigation. The listeners may or may not know that relators stand to receive a share of the bounty in a False Claims Act case. And so there are some financial incentives that can sometimes drive relators in pursuing and sort of staying in there for the long haul. The why now, I think, Jonathan, largely driven by some fascinating footnotes and concurrences and whispers that have been heard and seen and felt in more recent litigation. And for that, let me take you back just over 2 decades. In the year 2000, I think it was, the Supreme Court issued an opinion in a case called Stevens, which addressed whether relators have standing to pursue False Claims Act litigation on their own. And in standing, you've heard us talk in this podcast a few minutes ago that the issue that we're talking about today in this particular Middle District of Florida decision was an issue that was decided under Article 2 of the United States Constitution. The standing issue is actually an Article 3 issue. And in the Stevens case in the year 2000, this Article 3 issue was pretty handily put to bed. It is now the law, at least as articulated by the Supreme Court in the year 2000, that relators do indeed have Article 3 standing. But there is a tiny seed that was planted in the Stevens case by Justice Scalia on the United States Supreme Court at that time. And Justice Scalia made clear that he and that the court were basically essentially leaving open or sidestepping or very gingerly not opining on the Article 2 issues, not opining on the constitutionality of the Qui Tam provisions under the Article 2 take care clause and appointments clauses. That little seed was then sown about 2 decades later. We talked a moment ago about the Polanski decision, which is a case in 2023 in which the United States Supreme Court visited the issue of the government's power and ability to come in and dismiss a Qui Tam case when they had not already intervened. Well, in the Polanski decision, Justice Thomas himself dissented from the Polanski majority. And in his dissenting opinion, Justice Thomas wrote about whether there might in fact be room and availability for an Article 2 constitutionality challenge in the right case of the Qui Tam provisions of the False Claims Act. So in other words, he was sowing the seed that Justice Scalia had planted almost 2 decades earlier in the Stevens case. And Justice Thomas was not alone in expressing that sentiment. 2 other justices on the U.S. Supreme Court in 2023 who are still on the court now, and that's Justice Kavanaugh and Justice Barrett, concurred with that part of Justice Thomas's dissenting opinion. In other words, they expressed their agreement that in the appropriate case, the United States Supreme Court should really take up and consider this Article 2 constitutionality challenge. Well, it so happens that Judge Mizell, the author of the Middle District of Florida decision, had been a law clerk for Justice Thomas, not at the time that he wrote Polanski. She was already on the Middle District of Florida bench at that time, but she's obviously quite a brilliant jurist and had the opportunity to clerk for Justice Thomas. And so it's interesting to see that thread, or that seed, to continue the analogy, kind of now being harvested by none other than Justice Thomas's former law clerk, who's now on the bench. So you start with Scalia in the year 2000. You continue with Justice Thomas, concurred with by Barrett and Kavanaugh in 2023. And now you see Judge Mizell, harvesting that seed or taking up that mantle. So I think now, Jonathan, now is the time. The composition of many of the courts that have already decided these issues have themselves changed. The Supreme Court has indicated in the last term that at least 3 justices are welcoming to at least considering this position. And then you have, of course, Judge Mizell, Justice Thomas's former law clerk, now on the bench, who is, taking up this mantle. I think that's why we're seeing this, right? One of the courts that kind of foreclosed this argument in the past was the Fifth Circuit. We mentioned that a little bit earlier. And I think there might be some room even for the Fifth Circuit to reconsider its own decision. That was issued many years ago. And I think there may be room there for the entire Fifth Circuit to reconsider that now that it's been over 2 decades and the composition of the Fifth Circuit has changed as well. So my point to you is this is a great opportunity for the dynamic fluctuation of this aspect of the law to really come under reconsideration.
Got it, Jody. Thank you. Yeah, I think that history makes sense. The thing that some people don't realize is that constitutional arguments sometimes take a long time. These are not things that usually happen overnight. I know Above the Law, which is a legal practice website that I find very entertaining for a lot of their stuff, they sort of bashed this opinion saying this has been around 160 years. I mean, how dare you, judge, come in and say that 160 years worth of other judges were wrong? But the Qui Tam provision actually isn't that old. I think it was added in the 80s. And sometimes these things take time for people to say, wait a second, there's an Article 2 argument that no one's really thought about before. So these things do take time. I don't think this is, and it makes sense, Jody, the way you framed it, where it's been brewing for a while and it's just people are, making the argument. There are probably more receptive judges now. So, Lorinda, now I'm curious, tell our listeners a little bit about what happens next. This judge in Florida doesn't control the, entire United States. She just controls her one case. So what happens from here do you think there'll be an appeal? And Jody was just telling us about the 3 justices at the Supreme Court. How might this case reach those 3 justices in the Supreme Court? And obviously they need more than those 3. So Lorinda, prognosticate for us. What happens next with this case and this issue?
Sure. I think if we're looking at the sort of crystal ball, chances are that the relator in this new decision will appeal, as Jody said, to the 11th Circuit. Florida sits in the 11th Circuit along with Georgia and Alabama. The 11th Circuit right now, I think if you're looking just at the judges on that bench and which administrations they were appointed within, if you use just that as a barometer, it's a slightly conservative court. It's always possible that the court would reverse Judge Mizell's decision and say, no, look, this has been visited and we think it's still constitutional. That's possible. I'm looking in that crystal ball. I'm going to say, they might affirm. right? And if they affirm, then you've got to just kind of continue the seed and the planting analogy, I suppose. You've got like a full crop over here of decisions, the 10th, the 9th, the 5th, the 6th circuits already having visited this issue and saying, no, the Qui Tam provision is constitutional under the appointments clause, versus this one plant that now Judge Mizell has put out in the sunlight and put out there that if the 11th Circuit affirms her, then you've got a real circuit split. And that would make things ripe for the Supreme Court to pluck or take up the issue. And as Jody already said, we already know, because of Justice Thomas's dissent in the Polanski decision and Kavanaugh and Barrett concurring with the majority, but specifically calling out, hey, we agree with Justice Thomas that it seems like we ought to really look at this Article 2 appointments clause constitutional question in the right case. We ought to really take a look at that. That already tells you you've got 3 lined up that are open to supporting what Judge Mizell has written, right? So then we need another justice. And I'll call upon the two of you to look further into your crystal balls and say, what other justice might that be? How much traction might this get at the Supreme Court?
Thanks, Lorinda. Yeah, so I think it's really interesting. First of all, I think the relators bar, they're very well organized. I'm sure they're working out an appeal right now, and they're putting their smartest people on it, and they've got really smart people on their side too. So I'm positive they're working on an appeal right now. The 11th Circuit, that's my home circuit. I know the 11th Circuit pretty well. I'm going to be curious to see what they do with this, because while in general, the 11th Circuit does have more of a conservative lean, it's not necessarily a libertarian lean. You've got a number of conservative judges on the 11th Circuit that are more law and order than libertarian minded. And so I'm going to be really because I don't know that this is something that a traditional law and order judge is going to really grab onto. So I'm going to be really interested to see what the 11th Circuit does. I think this could be a lot more divisive than people think. So me personally, I'm really excited to see what the 11th Circuit does with this. But I also think this is going to take a little bit of time before we get there. The appellate process takes forever. And so people who are hoping for some sort of immediate relief in these cases, you got to understand it's going to take the 11th Circuit some time to hear arguments here, make their decision, see whether the Supreme Court grants cert, and then what happens from there. To me, there's a lot of uncertainty. So, Jody, while I'd love to hear your thoughts on, what the Supreme Court might do with this when it gets there, but also, Jody, tell our listeners, given this ruling and the time that it takes to go through appeals, what should those defending Qui Tams do right now?
Right. Such a great question. And, we can't offer, obviously, legal advice here on the podcast, but I think it is absolutely critical to keep an eye on this issue. Yes, it will take a while to percolate, but percolating it is doing even as we speak. And whether litigants are in ongoing Qui Tam cases or, at the moment dealing with investigations where there is at least knowledge or a suspicion that there may be a relator, it is very smart to be consulting with experienced, knowledgeable False Claims Act lawyers who can assist in preserving the issues and guiding the arguments so that they are litigated at the right time and with the right procedural devices. In the Zafirov case, the one we're talking about, the procedural posture of the case was a motion for judgment on the pleadings. That may or may not be, the way to do this, right? There may be other procedural devices that are available even earlier than that. As Lorinda mentioned, this was 5 years hence when these defendants were finally in a position to make these arguments. But I think it's really smart to be on top of this issue from the get-go and always be considering when or if it's appropriate to lay down this issue and get a ruling on it and get it preserved.
Yeah, that's absolutely right, Jody. Part of the reason why I enjoy practicing at Husch Blackwell is because I've got you two to help me with these big issues so that we can make sure that our clients are in a good spot so that we're bringing these arguments when they need to be brought. And so, Jody and Lorinda, this case is huge. This is going to continue to play out. So I'm grateful that you both were willing to come on the podcast, tell our listeners about this case and what they can do. So thank you both for coming on the podcast. I want to invite our listeners, continue to listen to us. This issue is not going away. We're going to continue to cover it. So however you're listening to this podcast now, it's probably got a little subscribe button wherever you're listening to it. So go ahead and hit that now so that you can continue to hear new episodes of False Claims Act Insights as they come out. We're going to continue to cover this and other big new issues in the False Claims Act. And so please subscribe, tell your friends about us so that you can continue to stay up to speed on this really interesting area of the law. But I want to thank everyone for listening today, and we will see you next time.
Thanks so much, Jonathan.
Thank you so much for having us.